Stephen Butter. I'm a practicing attorney in South Florida. I've been practicing for nearly 50 years. I'm the author of 3 books, 2 of which are on Florida family law. I authored in the late 1960s, early 1970s, a book entitled The Legal Rights of Women in Florida, addressing all sorts of rights, not just divorce, but the credit card debt, hospital bills, inheritance, right to sign a contract, right to buy a piece of property. When Florida established no-fault divorce, I wrote my 2nd book entitled No-Fault Divorce in Florida, addressing Florida Statute 61, which is the divorce statute. I'm also published by the Florida Bar Journal, our most prestigious publication in Florida. Most lawyers would like to get a divorce case settled, but if the litigants refuse to settle or just one refuses to settle, the case will go to trial and the judge will make all the decisions. It is always better to settle your case because you control the outcome of the case. If you go to trial, the judge will enter a final judgment dissolving the marriage and resolving every issue. If one side or the other does extremely well, the other side is going to file a motion for rehearing. That means what the judge said is not a final decision. It's subject to the judge's decision on a rehearing, or an appellate court will review the judge's decision and make a different decision if the judge made a mistake. That's why it's always best to settle the case. The issues in a divorce case that you may be involved with would be alimony, child support, medical insurance for the children, medical insurance for yourself, equitable distribution of the assets acquired during the marriage, equitable distribution of the debts incurred during the marriage, restraining orders, restraining someone from taking money out of a bank account, restraining someone from visiting with the children with his girlfriend or boyfriend. In writing up the decision or your settlement agreement, experience is the key. The language of the agreement is critical. For example, if the paragraph says that the husband pays the wife $5,000 a month, period, that sounds pretty good. The wife thinks she's going to get $5,000 a month. What happens if the husband doesn't pay? She files a motion for contempt, saying that the agreement said $5,000 a month. The husband responds by saying, yes, it is $5,000 a month, but it doesn't say when I have to start making the payments. So at this point, I haven't violated a court order, and he's correct. Experience is the key in writing up a court order or a settlement agreement. Going through a divorce case is extremely emotional. Everybody has very, very sensitive emotions as to what happened during the marriage to bring them into the courtroom or bring them into a lawyer's office. If you find yourself in a situation where you want to consult with a family law lawyer or you're involved in litigation in a divorce case, you can call me, Stephen Butter. My personal cell phone is 305-333-7159. My concentration is going to be on resolution rather than litigation. Working it out through negotiations with good counsel on both sides would be in your best interest.